We're back now talking with Don Samuelson. We've been on a really interesting role here, and we're kind of getting down to the testimony and to the idea that the people actually lied under oath and that the judge believed them. There was no real evidence submitted. So, you're an attorney, Don. What happens when somebody lies under oath? Didn't the judge realize that the testimony was false? Why was there no evidence?
When you're in a courtroom, you simply hear evidence and you get a sense of its credibility. You don't know whether it's false or true.
Okay.
Like Drew Peterson, they're going to be determining that situation in the future. But the lying under oath, there's a couple things that are things that HUD personnel ought to worry about. One is there are certain codes that HUD has for truth-telling in documents that have penalties of $250,000 in fines and 5 years in jail for false testimony in documents. Now, that's not necessarily perjury. Perjury is a different concept. Perjury is the knowing statement of falsehoods. It's a state of mind. It's not only that we are wrong, but we know we're wrong when we're saying it.
And we say it anyway.
Yes, that's more difficult to prove. It requires extenuating, it requires more than just, is this false?
And is that what happened?
No, at that point we were still dealing with their ability of making what turned out to be false statements that influenced the judge, but they weren't elevated to a question of perjury at that point. Now, then, however, as we got into the administrative process, something that will be more serious is that Hinsberger wrote in October that the vouchers began to issue on October 1st. He and Greg Guston communicated that up to a third of the vouchers had been issued by December 15th of 2001.
Greg Guston was the legal counsel?
Yes,
refresh my memory.
Yes, he was the great Santini, I guess we'll call him at this point.
I think the legal counsel will work.
Will work,
correct,
okay.
Yes.
So, and then a little bit later on March 8th, he said, Hinsberger wrote, Greg Guston, Attorney Guston wrote for Hinsberger to write to HUD in Washington that almost all of the vouchers have been issued by March 8th. Later on in the testimony trial, Hinsberger says on 2 occasions the vouchers didn't begin to be issued until June of 2002, when they in fact been going on for 9 months. Now that begins to be something that could be raised to the elevation of perjury if Hinsberger knew that it was false when he was saying it.
All right.
Now, a couple other things that happened at that point in the review process, which are problems for HUD, is that one, Guston wrote in the first appeal, where he was the judge and jury, that the judge had already solved the problem of the breach of contract by his injunction ruling. That's clearly not the case. To receive an injunction, you need an extraordinary standard to be reached. Not just that you're wrong, but it's so wrong that it has to be redressed right now. Greg was fairly happy to conclude that that was decided, and it was clearly not. The second part of this is that...
Why was Greg not savvy enough to realize that a decision had not been reached?
Well,
he's an attorney, yes?
There are attorneys and there are attorneys, and
right.
and there are also, it was his position at that point, 2 positions that are important.
But he was legal counsel to the director of HUD.
Yes, he was. And he was telling everybody at that point that there is no review of this decision, that every decision made with respect to a HAP contract was unreviewable. Therefore, whatever they did, nobody would ever know about it, so don't worry about it.
Unreviewable just cause?
No, unreviewable in the court.
Okay.
There are certain things that are discretionary activities in a government agency that are not reviewable.
All right.
Most are, however, but anyhow, Guston thought this was one, or represented that this was one that was not. The other thing he did, which was even more troubling, is that he was supposed to have been removed from any further discussion of this when they get to the final appeal. He actually wrote the final appeal. Not only did he participate, he wrote the final appeal for not just the Hinsberger, but Howard Mayfield in Washington. Now, Hinsberger later at trial said that wasn't the case, but you have witnesses. Margarita Masonette said that was the case.
Should he have been able to do that?
No, he should not have been able to do that. And that,
All right, let's pause there. We're going to come back.
Okay.
I have a feeling this is going to get more interesting. We'll be back.